Welcome everybody to this month's Construction Contract Administration Practice Group. So with that, I want to hand it over to Douglas and Jim to get started with today's session as I get the slides going. So Douglas and Jim, if you want to do any introductions or get going with today's topic, it's over to you.
Doug, you want to start us off?
I just want to say hello to everyone and welcome everyone back as we continue this four-part series. We're going to go into part 2. And as Jim mentioned last time, this is going to be more of a present this scenario situation and talk about some of the issues that it raises and some of the possible solutions. So we're really looking forward to it and hoping that we'll get a lot of feedback from the audience today.
Absolutely. Thank you, Doug. That's right. We are very interested in your perspective of these issues. We started this in part 1 towards the end of the conversation. So we'll pitch you some scenarios of things that we've experienced and post some ideas of or some questions about what you think might be the right solution. Matthew can look for those raised hands or chats and send those out so we can connect and hear your comments or read your comments, either one. And then we'll go through what our experience was with some of the answers and also touch on some of the points that go along with the question that is at hand. So, and then in the end we'll summarize the scenarios that we went through before we end the call. So Matthew, the first title slide there is called Timid Play. Now let's go to the next slide. In this scenario, the owner on your project has approved a change that you had recommended against and that violates the code requirement in the area where your project exists. So what happens now? Let's look at the next slide for some potential answers. So again, this code change has been made against your recommendation, and it was something that the owner approved for the contractor to do. Oh, I should also say our typical assumption with our scenarios here are a design, bid, build kind of relationship. So that's the basis of these scenarios. So does the architect just go along with the change because it's the owner's property? Does the architect take the position that the contractor is directed not to make the change and the architect issue that direction? Perhaps does the architect report this to the authority having jurisdiction and the building inspector that is associated with the project? Or does the architect terminate his service or her service with the project? Perhaps on the first attempt to correct, this is not a requirement to terminate services, but perhaps on the second attempt you are able to. Now this may be contract language that exists in your area. You certainly would want to be sure to understand your local or regional laws and statutes, but so option 4 would be that you would just terminate your services on the project because this has occurred. Doug, is there anything you want to add to those possibilities? I want to go to a slide and sort of explain the scenario a little bit.
No, I think that's good. Let's keep going and get the audience to start thinking about either one of these 4 options or a different one that's not presented here. We can keep going and see what we discuss.
Okay, so Matthew, let's take a look at the issue was that there was a sloped roof assembly and the construction documents showed a standing seam metal roof with a 2 and 12 slope. The contractor and the owner got together and said, you know what, we got an idea here. We think we put asphalt shingles up here in lieu of metal, and the owner will be able to save a lot of money, which sometimes owners want to do. But by installing these shingles on a roof slope that was lower, a bit lower than 2 and 12 as it was constructed in the end, the contractor had violated the applicable building code in the area. And of course, as you might imagine, then there was significant water damage that occurred to the sheathing and the interior spaces. So let's keep this slide up, Matthew, and see if we've got any comments from any of the participants at this point, or ideas, as Doug said, of potential additional answers or thoughts about the answers that were offered.
Alrighty, we don't currently.
We're waiting for some feedback. I would also, I'm sorry, Matthew.
Oh no,
like
we currently don't have anybody yet, but feel free to jump in.
I'd like to add in for folks to think about or comment on what they think the architect's exposure liability-wise might be in this situation as well. Jim, it doesn't look like we're getting.
Oh, we have we have one comment here just popped in from Chuck Coleman. He said, "What was the architect made aware of, or when was the architect made aware of the change approved by the client?"
Well, the architect was included in the consideration of the change and did not know that it was going against her wishes until arriving at the site to see the work underway. Well, let's go, Matthew, to the response slide, the next slide, and share solutions. This project was in North Carolina, and in North Carolina, and I'll let Doug go a little further into these, but it is a requirement when the architect is aware that something has been done that is not following the applicable code, that it must be reported to the authority having jurisdiction. There is no option there. Certainly you wouldn't go along with a change that was against the code, and this architect had already recommended against the change. But in addition to these items, what also was done is that the architect notified the owner and the contractor in writing that this was not in compliance with applicable code and that she would not be responsible for the design. Also, she issued a notice of non-compliance in the field and rejected the work and directed in that notice of non-compliance that the work be removed and installed in accordance with her plans and specifications. We've talked in the past about what a notice of non-compliance is, which is Doug. Well, let me just rush and let Doug talk.
Well, to go along with the change and not say anything would be negligent and would open yourself up to liability. As Jim was saying, I know in North Carolina our statutes require that if the architect is made aware of a change by the owner that does not comply with the building code, and you cannot convince the owner to comply with the building code, that he is required to report it to the authority having jurisdiction. That can kind of put us in a sticky situation, going and telling the powers that be on your client, but in North Carolina you're obligated to do it professionally, and if you don't do it, then there's a whole another set of ramifications that you're going to have to deal with for violating that statute. So as Jim said here, the steps to do would be to first try to convince your owner not to violate the code. If you can't do that, then the items that Jim has on here, the 1, 2, and 3, I would say all need to be done. But I would think what I would do prior to doing 1, 2, and 3 would be having another conversation with the owner to let him know this is what I have to do in order to maintain my practice and not get myself in trouble. And you're forcing me into this situation by not agreeing to comply with the code. So you're giving full disclosure to the owner, because he's not going to be happy when the building official shows up on site and says, wait a minute, you got to stop work and tear this stuff down. I'd be interested to hear from the audience if anyone has ever been through this. I know I have, and I've had to have that conversation with the owner. It did not go to the point to where the authority having jurisdiction had to come in and assert its authority. The owner realized what he was doing and agreed to comply with the code. Jim was going on talking about notice of noncompliance. CSI has a form, and I don't have it in front of me, Jim. I don't know if you remember the form number, but it is a form that is specifically for notifying, giving a notice of noncompliance. As Jim said, we've talked in the past about how important it is to not use a form for a purpose other than what it's to be used for. So although you can note it in a field report to make sure you're bringing everyone's attention to it, I would not only note it in the field report, I'd also issue the notice of noncompliance.
I'm not sure off the top of my head. I want to say it's 9 point something, but I'm not sure, Doug. Maybe we can look that up and post it with the taped version here. Matthew, are there any other hands raised or any points there?
We do have quite a few comments that have popped in here, so I'm just going to read them in order, and hopefully they'll help address. So first one came here from Ralph, and he was wondering, was a change order issued, and did the contract documents direct this change?
That's a good question, and Jim, I just looked it up in the practice manual, the CSI Form 9.8A, Non-Conforming Work Notice. That's a good question as to whether it was a change order was issued.
No, there was not. In fact, maybe as you're reading these, Matthew, let's go to the next slide, because there'll be some of this maybe clarified in the next page, or you share those with us. But you'll see here, there perhaps some of the mistakes that were made, and let's skip down to number 2. Perhaps this occurred because there was poor paperwork processing and follow-through. And, Doug, we talk about this all the time, where you have a period of time that's a timely response to an issue or an item. If perhaps, back to number 1, the architect had been a little more forceful in saying, no, it's not that you shouldn't do this, but you cannot do this. And here's paperwork denying the change order request on the basis of non-code compliance, so that there was some paperwork that followed that up, rather than a phone call between the architect and the owner that wasn't documented that said, no, you shouldn't do this. But there was not a change order issue.
Alrighty, we have a few comments I think that actually kind of tie into what you're talking about here. So with paperwork from Jim, he says, can the AE provide a document that absolves him or her from any litigation and responsibility once they are informed of a deficient installation?
Unfortunately, there is not, I don't know of any way that you can prevent from someone filing a claim against you. But having the paperwork to show that you advised the owner that it was against code and that you recommended against it and went through the steps like Jim had put up before. When you go to court and you have that evidence to present, then chances are you're going to have a short time period in court defending yourself in the case will get dismissed. So that documentation is important to have, but just because you have it doesn't mean you don't have to go to court to show it, to prove it.
And then building off of that, Thomas made a comment here. Work cannot be changed without field order. Work change directive or change order needs to be signed by all parties. Also, contractor performing work has obligation to indicate that the work is non-compliant with code.
That's right. There should be no changes without the proper documentation, and that's one of the things that needs to be established all the time. And in fact, it's going to be a great segue into the next topic that we talk about. I'll just mention on item 3 and item 4, and one of the potentially the missed opportunities here is for the architect to have seen this issue, understood the owner's need to save some funds, and perhaps use that as an opportunity to provide services that aren't included maybe in the CA phase, where she may have helped them understand that in the short term this may have been a good solution, but in the long term with the life cycle costing considerations, etc., that this may have been a detrimental move financially to them. So, I don't know if that was a part of what may have happened, but certainly there may have been an opportunity once that proposed change was made to say, hold on, but let's do some estimating here and take a look at what really you're going to save. And then also the fact that it was well underway before it was ever seen in the field may indicate that there wasn't enough construction administration site time being expended to look at the status of the work. Matthew, are there any others?
There is. One of them, just as a side note, Charisse wants everyone to know that if you want to follow along, she's tweeting under the hashtag CSICapg. So feel free to join Charisse there. But actually, I'm going to go back a slide here because Rex is wondering, can you tell us in more detail what's wrong with option number 2?
The issue with option number 2 is that if you're the contractor and you got an architect telling you, I want the standing seam, and you got an owner telling you, no, I want the asphalt singles, more than likely what's the contractor going to do? More than likely he's going to follow the direction of the owner who's writing the checks to pay him and put the asphalt shingles on. So it's not that necessarily that it's wrong. I think letting the contractor know as well as letting the owner know what the issues are is the right thing to do. But just going to the contractor and relying on the contractor solely to do the right thing may not be good enough.
And there's a piece of this which, follows the chain of contractual agreements too, and that you're contracted with the owner in this case, and the owner is contracted with the general contractor. So there isn't a direct line of communication there on this project.
And that actually brings up a question that came in here from Jim. If a change order is not signed by the AE, but by the owner, is it still legally binding, and is it considered part of the contract documents?
Let's go. Are there any others, Matthew, besides that one?
Just a side comment from Rex saying, did the local building inspector have a chit-chat?
Yes. But let's save the question about the change order and go to the next topic.
Okay.
Because I promise you we're going right into this. So this title of this issue is applying the rules unevenly. So let's go to the next slide. So the architect and the contractor approve a change order. And they do that with the owner who's present, and the owner verbally approves this change. So they've made their verbal commitment in the field, looking at the conditions. The contractor proceeds with performing the work, completes the work in accordance with what the architect, contractor, and owner had talked about, and submits a pay application for the work. Well, what happens then? Let's take a look at the next slide. The owner refuses to pay because there is no valid change order. There wasn't a signed change order that was signed by the owner. Of course, there are many reasons to be sure that this does not occur, and your fee is one of those. Or, answer number two, the owner pays the additional cost. They made a verbal agreement, and work proceeded, and they were a party to it. Number three, owner sues the architect for negligent performance because they had approved the pay application, which included work that was not a part of the contract documents. And because of all this, number four, does the architect end up paying half of this problem and the contractor absorbing the other half because there was no contractual obligation in the first place? Let's take a look at the next slide, which are photographs of two of the issues. One was corrections of work that were unknown, unforeseen conditions that were beyond specific requirements, where issues existed with connection to existing construction. But the other was, I kid you not, that was installed just like you see it there, redoing work that was done exactly like it was shown in the construction documents, but was not obviously coordinated in the field. So the graphic representation was there for rough-in and for building component, but no field coordination. So these were the two issues that were change orders, which may help better inform what those selections were. So unknown field conditions and work that was done but had to be redone. So let's back up a slide if we could, Matthew, and take a look at the choices again. Again, remember that the owner was a party to the conversation and agreed to pay additional money for the changes. But then once they were submitted and came through on the change order, they did not agree to pay. Doug, anything to expand upon on that?
No, I think we're ready to hear what everyone has to think about this situation. So Matthew, have we got any comments yet?
We haven't had anything yet. Glenn, I sent you a message. Your hand is up. I'm not sure if you wanted me to unmute your line or if it may have been tapped by accident. So Glenn, just send me a chat if you want to join in the conversation. As well as anybody else, feel free to raise your hand or type in the question box as well.
While we're waiting, Matthew, I'll just add one thing that is, and I apologize, is a limit to this type of presentation, a limitation. There are so many components of these scenarios that I can't or don't get included in these slides, and I apologize for the what-ifs portion of this, because there's a lot of detail that would be helpful to be included that with the slides to say, well, you know, did they do this or did they do that, and when did this happen and when did that happen, and they are all important components of the conversation. And what Doug and I have tried to do is sort of get it down to, you know, a minimum verbiage so that we can allow time for conversation.
Well, with conversation, we do have two topics or comments that came in here, and a third one just popped up. So Ralph says change order needs all three signatures, so not a valid change order until then, and no change to contract documents. And building off of that, we have a comment here from Jim saying he would hope the owner would pay, but he's experienced number 1 and number 4. So I have a feeling Jim has some war stories for us.
Yeah.
And then the other comment that popped in here from Thomas, he said that the owner would pay. Contractually, work should not have been completed without change order. It was done on verbal with the owner indicating was good. Result, the contractor claim.
All three of those are excellent comments. I think depending on the parties involved, the personalities of the people involved, the integrity of the people involved, you could have any number of outcomes. Per the contract documents, the change should not have occurred until the change order was signed by all three parties. Now, I have worked on multiple projects over the years and oftentimes see work being done well before a change order is signed. I'm sure we all have. It's something I try to guard against and am not always successful in doing so. But if you are successful in doing it, then you don't have to worry about this type of a situation occurring at all. You've got issues with the owner, whether the owner was acting in good faith when he verbally approved the change order, and now he's denying, presumably denying that he approved the change order verbally. There's a whole set of issues there that if the parties couldn't come together and resolve amicably would be a whole interesting court case to be a part of. The point of this, I think, if you go back to the slide that introduced this, was applying the rules evenly. Not that you need to go back, Matthew, but the title of this was applying the rules unevenly. Is that the language in those documents, AIAs put together and the AI documents and other organizations put together, is there for a reason. And it has been tried and true and tested. And so when you start doing things that don't conform with what you have contractually agreed to do, you're going to get into trouble. And you could end up with the 4 situation where you end up paying for something when you really were not at fault. You could end up in the 3 situation where you get sued for doing something when by all intents and purposes our parties had agreed to what was going to happen. Hopefully you'll end up on number 2, where if the owner has verbally agreed that he pays for it and it's not an issue. Or you can end up with the item number 1 scenario as well. So as Jim said, we're not listing all the facts and all the ins and outs of what could have happened in these situations, but this is just to spur discussion and get you thinking about these issues and how to deal with them as you might run into them out in the field.
That's right. This scenario actually, as Doug touched on, and I think one of the participants pointed out, you know, there was agreement, obviously not in accordance with the contract documents, because you're right, everyone should sign the change order to make it valid. And thankfully for those involved in this job, there were too many people present for the detailed conversation where the owner agreed to pay the cost. The unforeseen condition really started in that direction of, well, nobody could have known this, we don't have a choice. The conduit that was roughed in improperly really sort of happened with some of the owner's influence in trying to arrange for a countertop reception area. And so they had a little culpability there. And so it was a scenario where, with proper field coordination between the electrical contractor, the GC, and the casework installer, along with the architect and engineers, it could have been avoided. So the owner was very upset, wanted to sue, because unfortunately they felt like maybe they'd gotten away with something until the architect signed the pay application. And of course they argued about who was going to pay for what, and in the end, though, the owner did do the right thing and stepped up to cover the cost. But so don't fret. We'll move away from this slide, Matthew, to the next one, and just talk a little bit about what are some of the expectations upon the A&E firm from the contractor's perspective, because there may have been an opportunity to avoid all of this, and we'll conclude with looking at what maybe some of the mistakes were. But the contractor expects us to assist in expediting the work, to be available when the progress of the work is needed, not just when we're needed. So hitting our timing so that these issues don't blow up into bigger issues than they need to be, and being responsive with prompt responses is important to them. And then, of course, processing pay applications is an expectation of keeping the project moving, because it all turns on the finances. And also doing prompt review and complete review of the submittals. So in this case, there may have been an opportunity to catch some of this. Unfortunately, things were roughed into the slab early, as usually happens. So maybe the casework wasn't there in time to see that this rough end needed to move. But there may have been an opportunity to avoid some of this there with timely processing the submittals, which we also talk about is so important. And the final expectation is to be fair and reasonable. We need to be professional. We are a party of this team to be impartial and deliver information based on what follows the code and is right, and not to pick a side. So these are some of the things that I think we need to keep in mind as we're dealing with issues, whether it's before that issue presented itself or during the process. And so let's look at then maybe what some of the mistakes were, and we'll talk about both these slides if we could, Matthew. The next one is maybe we weren't following the proper documentation process, and as we often do under the restraints of time, said, go ahead and proceed with this. We're all good. We got it worked out here in the field. And we didn't go back to our office and do the proper paperwork to follow up. There was an opportunity to be sure that the owner didn't just hold this change order on their desk. It was not an oversight. It was a purposeful action. So perhaps a little better communication with the owner would move that piece of paper in front of the pay application so that it was properly documented, and that there was obviously better communication, documented communication, so that the paperwork followed the conversational trail and followed the changes that were being made. Now, I said a lot, Doug. I want to be quiet and give you a chance to talk about those expectations and maybe what some of the mistakes were and if there are any questions.
Well, I don't have much to add, but going back to the question that we got before going to this topic was the change order not being signed by the architect, is it still valid and a part of the contract documents? My response to that would be no, because per the contract, for the change order to be effective, it needs to be signed by all three parties. So if it's a change order, the owner, the architect, and the contractor, all three have to sign it before it becomes a valid change and becomes part of the contract documents. So whether it's the owner that hasn't signed it, the architect that hasn't signed it, or the contractor that hasn't signed it, with lacking one of the three signatures, then it is not a valid change order and not a part of the contract documents. And that kind of comment on the previous slide on being fair and reasonable, that is a ethical obligation, obviously, but it is also a professional obligation and also a legal obligation. It is in the contract documents that when the architect is the initial decision maker, I'm not sure that's the exact phrase I use in the new AIA contract language or not, because it used to be that disputes came to the architect automatically, and now by contract the owner and contractor and architect can agree that the architect is not going to be the initial decision maker, it's going to be someone else. But if it is the architect, by contract it's in there that you are to be fair and reasonable, and you shouldn't be taking necessarily the side of the owner just because he's the owner. You need to do what's right. And it's also a professional obligation. If you look at AIA canons, and assuming that we're all members of AIA, and also if you look at your professional licensing law requirements, it's in there that you are to be fair and reasonable, which again could be seen as a conflict of interest. The owner's paying you, you're working for the owner, yet you have to act as this independent third party when looking at disputes. So just be conscious of that. So Matthew, have we got comments from people?
Yeah, we have two comments here. One from Jim Carlisle saying he's attended pre-construction meetings where the owner's representative would state that no extra work be performed without completely executed change order, and then right after the meeting ask a contractor to perform extra work immediately without the change order document. But based on his word? Question mark. So it comes down to how much one's willing to trust the other and how much money one is willing to risk. And then we have another comment. We have another comment here from Thomas. Is I guess much more of a reprimand for any of you out here that may be following the example number 2 here and saying shame on the AE and contractor for even placing it on the pay app without fully executed change order signed by all parties.
That's a great point. That's exactly right. And Doug and I have worked on projects together where, if we talk about timeliness all the time, that pay app comes in and it's not, change orders on there and it's not executed, and you know that, and ship that puppy right back out the door. Because it shouldn't show up if it's not a contract modification. You're absolutely right.
I've had a pay app come in that had some additional work on it that I did not even know the owner had agreed or talked about with the contractor. With doing site visits, not out there every day. It was after my last visit, prior to the pay app being prepared, and it was just a matter of a couple of days actually, where I got the pay app and I had just been out there and this work is showing up. And I'm saying, well, what is this? And I called the contractor and well, the owner was out yesterday and he wanted me to do such and such. So I went ahead and did it. I didn't even know about it. And there certainly was no change order. So the work was done. The owner authorized it. The contractor wanted to get paid for it, but it wasn't going, he didn't follow the proper process. So you just have to be aware and be vigilant, and in that case I just told him, well, I can't prove that because it's not a part of the contract documents, and we struck it and then did a changeover for it.
So that's a great parlay.
Oh.
Okay, you go ahead, Matthew.
I was going to say we have two comments here that I think might work as a good summary before we move on to the next one here. So Thomas just typed in documentation, documentation, documentation. And I think tying that into Sharice's comment here, theme of this one can just be lack of communication and better coordination. We need to do a better job of educating and communicating with all members of the project team.
Well, if you thought that about this one, then you're really going to enjoy the next one, because you're absolutely right. So the next topic is getting sucker punched, and the next slide will explain a little bit about what that is. So this particular project, the contractor convinced the owner to make some changes to the project. Maybe this is just a problem in North Carolina, Doug, I don't know, but it seems to be a part of many of the issues that we talk about. So this is I'll give you a little more information. This is a brick structure, and there are multiple buildings, and so for whatever reason, which may be based in the contractor buying some brick tile at a fire sale price, I'm not sure what drove this, but the contractor's idea is that there's a way that on two sides of this building we don't have to use full brick. We can just use a brick veneer that we're using in some other places in the building. And in fact, we were using these inside in some inside applications at hearths and fireplaces. So, and it matches the brick exactly. So we think we can take two sides of this building and just put this veneer on, be much faster. It's going to look exactly like the other sides. You won't see these two sides when you see the other two. And we'll do that in lieu of the traditional brick veneer. And we think it's going to save you a pile of money. Well, in this case, the architect was not aware of what happened and was not a party of approving this change. So the contractor moves ahead with installing the interior grade tile directly to the exterior substrate, no drainage plane, and believe it or not, it was an adhesive-based application, and so that's what they used. And so what happens now? Let's take a look at the next slide. Is the contractor responsible for repairs and for replacing the tile with the specified product? Or does the owner have some culpability in paying for and replacing those tile with a specified product? Might the owner, in this case, sue the architect because we didn't do a better job of keeping her out of trouble, and we were negligent in our CA duties for not having stopped this? Or the always popular choice, does the architect get invited to pay for half of this problem because of number 3 above, and the contractor absorb the other half? So if you take a click to the next slide there, you can see an example of what started to occur. Is it's maybe a little hard to tell in the slides, but the tile was just basically disintegrating in place, as was the substrate. And of course, that's absolutely the wrong material and the wrong application. And I don't know if you can tell by the moisture meter there, but that's 0.1 shy of 100%. So things got a little bit wet on the inside of this project. So if you want to click back to the back one slide to the potential answers and see what does anybody think about this one. If you don't have any comments, Matthew, we can take a look one slide beyond the photographs and talk a little bit about what should be happening while we're on the jobs. You know, who has a role to observe the work? Well, all the parties do. Everybody has a role. For the constructor, well, it involves quality control and continual inspection, which they have control over the means and methods of doing, and the scheduling, payment of subcontractors and vendors. They're responsible for inspection of the work to determine that each portion is ready to receive the next, and that the authorities having jurisdiction have been coordinated and signed off, and that all of this is done in accordance with the plans and specifications. In our role, it's stipulated in our owner-architect agreement, and that might, obviously it does, differ from state to state, but is as required by your state licensure requirements, and also in accordance with the standard of care, you know, where you are and where you practice. The owner, though typically is not provided a role in the field observation portion of a project, they may have staff who do, and when they do, then they are there as a part of the team to do observing as well. Any comments, Matthew, from the potential?
We have some comments that may be connected and or contrasting each other. So I'm going to go back a couple of slides here. Chuck says it's probably 1 and 2. Where we have Larry, who just in all bold capital letters says, when was the architect made aware of this change? And I think Barry leads into that by saying perhaps you need to visit the job site more often. And then Jim Carlisle puts in his should be number 2, his decision, his problem. The AE was not included. And then we have the last one here coming in from Thomas. Sounds like coordination and communication issues with all parties. RFI could have been initiated to start the review and process consideration. Was AHJ consulted?
Well, I'll share with you a little bit more.
Jim,
Go ahead, Doug. Yeah.
let me start with that last comment, and it goes back to something I said earlier about using the right form for the right purpose. And in this case, the RFI would not have been the method that I would have recommended to be used. The contractor wanted to change from using full-size brick to a thin brick, and that would have been a substitution. So the proper format would have been for a substitution request would have been issued to the architect for the architect to review and evaluate and respond to. I am a big proponent or opponent of using RFIs for anything other than RFIs and not using them for substitution requests or any other reason other than to request information for interpretation of the documents. So, Jen, I'm sorry again.
Oh, no. I apologize, I don't remember whose name it was, as hit on some of the things that we'll talk about as perhaps some of the mistakes here, but to answer the question about when did they know that this was occurring, the brick tile were already in place, and in fact some had been in place long enough for them to already begin to fail. So obviously that is not the kind of service in job site observation that we are expected to do. And we have this conversation and debate in several different ways, but it comes down to what your licensing board requires. And often firms are not included in the construction administration phase. And I say that, and people look aghast. But some of us are fortunate to work on projects that are large projects that have complex ownership and contracts, and if you'll allow me, they get done out in the very brightest light of day. Some of us have projects that are a developer-driven model that was bid to a contractor to keep some arm's distance in a project, but then is awarded to a contractor who in the end knows that developer and perhaps the owner. So you almost find yourself representing your firm and maybe the lending institution to be sure that things don't go so awry. And so in all of these various forms of project delivery, there sometimes becomes a relationship that maybe is too close to one another for it to have the brightest light of day shone on it. And some of these scenarios come out of those relationships where there wasn't enough distance between the parties. But this actually happened and was put in place before the architect even knew what was going on, which indicates that CA was not a large component of their contract. Matthew, there are others?
We do have a few other questions that have popped in. Thomas I just read that one. So Chuck has a question, or two questions actually. Was this thin veneer an appropriate detail if a rain screen had been provided? And he states here, for architect to be responsible, the change would have to have been incorporated in the contract documents, correct?
Yes, and there was not. It was not anything near an appropriate material for an exterior installation, just the material itself.
Well, that wraps up all the questions and comments we have currently, so
let's go to the next one.
Probable solution. There you go.
There you go.
So those that, in this case, it said 1 and 2, fortunately this was a fight for the contractor and the owner to have. Obviously the contractor was responsible because they had proceeded without it being a formalized contract change, and the owner, because they had agreed to have this as a solution, were also involved in the repair and replacement with the specified product. And that's the way this one shook out in the end.
There could be a scenario where the architect does end up being on the hook, and that would be if the architect did have construction administration services, did not notice this change, and had been out on the site while this work was proceeding along, and didn't notice it and didn't say anything about it, or did notice it and didn't say anything about it. If that were the case, or those facts occurred where the architect was on site, saw it, didn't say anything, or saw it, or was on site and did not see it and did not become aware of it when he should have, then he could be held negligent in performing the CA services.
That's right. And if you look at the next slide, Matthew, in some of the mistakes, I have a friend who I think the world of that says when you're out on a job, one of the things that you want to be is conspicuously present, so that if you document properly, people have seen you, they know you're there. That has a positive impact on a project from start to finish. And that clearly was the case here. As Doug said, this architect dodged a real bullet because they did have CA, but were able to prove that it wasn't at the level of what the standard of care usually is, because it had been written out of their contract for that level. And also, obviously, poor communication was going on this project. It's just, all of these are cases of what we all hope not to do, and while we're all together, on these calls, learning from each other. So in the summary, which I think should be the next slide, of all of these that we've talked about, in the first scenario in timid play, it's important to be direct and professional all the time. Always communicate and document the facts to the team. And we all know this through life experiences. It's better to go ahead and have the hard conversation and start to get over it than it is to be timid about it and not be direct. And when in the second scenario, and applying the rules evenly, the project needs to be managed as your contract for services and your contract documents require. And you should do that at every moment, and you should expect the same from all the other parties on the team. And if you manage the project that way, these opportunities, if you want to call them that, can be avoided. And then finally, the third scenario, getting sucker punched. Conspicuous presence at the site gives you the opportunity to know what's happening and to offer timely observations and keep things from going awry and going too far in that misdirection. So those are sort of the salient points that we hope came across in our conversation today.
And Jim and Douglas? Yeah, I was going to say we have a question here from Mark that might be interesting. He's saying, if instead of this being a design bid build, if this was just a DB contract, would that have had affected the outcome of this scenario?
Regarding the very last scenario with the thin brick issue, I don't think that it would have had much of an effect. The design professional was not aware. The design professional was not providing full CA services where they were visiting the site in frequently enough manner as to where they would have seen it. So I don't think that liability would have extended to the design professional in this last scenario. So I think it would have still fallen back to 1 and 2 with the contractor being responsible and the owner being responsible, where the owner had agreed to switching the materials with the contractor's input. Now, personally, I think it might be more of a contractor issue than an owner issue. And if I were representing the owner, I would certainly be pointing out that my owner is not a building professional. He is whatever profession he's in, and he has hired these experts, and he's relying heavily upon these experts to guide him in making these decisions, and he wasn't guided properly, which would, I think, be a strong argument in favor of the owner not necessarily being as culpable as the contractor was in that situation. Anything else, Matthew?
Just a comment came in here from Jim Carlisle saying, in a DB scenario, the contractor assumes the design aspect of the project, so the responsibility is solely his. So I think it kind of ties back into what you were just saying.
Okay. The one entity, the design build firm, who's responsible for the design and the construction. Typically, they do consist of two different people, so to speak. You have the design professional and the constructor, the building, the contractor, and assuming that one or the other is contracted, let's say the contractor is contracted with the design professional to provide these design services. The contractor would be responsible for those services to the owner, as though the design professional was a subcontractor to the contractor. So in either scenario, assuming that there was a design professional, again, I don't think liability would have reached to the design professional. It would have stopped at the contractor. So,
I see your, oh, sorry, go ahead, Doug.
I was going to do the same thing you were getting ready to do, Jim. We're covered our topics for today, and this slide here is leading into the presentation for next month in February, where we will continue on with part 3, and that's February 24th, again at the same time at 12 o'clock. And we do thank everyone for participating. Suggestions, comments, please feel free to contact Jim or myself. Our emails are now on the screen. Jim?
Absolutely. You wrapped this up just right. I appreciate everybody being here. Send us your ideas, and we'll talk to you in February.
All right. Well, thank you, everybody, for staying a few minutes after the hour. Again, look for the recording to be on the YouTube channel in the next few weeks, and we look forward to seeing you in February. Bye, everyone.